Isaiah is another good friend of mine, very good friend of mine. I'll just quickly read his bio. He's a partner at Bozimo and Company, a practice specializing in arbitration and dispute resolution in Abuja. Isaiah's reputation for delivering high-value settlement and victories has earned him recognition as one of the rising stars on the African continent. He has represented state-owned entities, corporations, and high net worth individuals in several ad hoc and institutional arbitrations. Isaiah has also served as sole arbitrator and co-arbitrator under the rules of the ICC, LCA, and etc. Isaiah previously served as a representative of the ICC YAF, that's for Africa, Middle East, and Turkey. He has provided strategic guidance and mentorship through free workshops for young African legal practitioners. In addition to being a member of the ICC and fellow of Prime Disputes, his leadership qualities has earned him an appointment on the drafting committee for Nigeria's Arbitration and Mediation Bill. Isaiah has been recognized as one of the 50 most promising arbitration practitioners in Africa, and the Who is Who Liga has been featured in by the Who is Who Liga 2020 and the 2021 as a future leader in arbitration. Thank you very much, Isaiah, for agreeing to speak. You may take the floor now.
Bayomi, thank you very much indeed. Good afternoon to everyone joining us. I've enjoyed the presentation so far, particularly Professor's reference to computer chips being implanted in human beings. And if you've had the pleasure of speaking with Professor Wahab, you would only but wonder whether he's an early adopter of that process of being technologically enhanced. He is a man of vast knowledge, and I hope each and every one of you will have the opportunity of speaking with him one-on-one at some point. Well, onto the discussions. So I will be speaking specifically on points you should consider when organizing remote proceedings, specifically arbitration proceedings. And we've heard a very good sort of framework from Prof regarding how ODR has evolved, and from Madeline as well, taking us through some of the platforms and some of the points you would consider, and you would find that some of my talking points overlap. So I wouldn't spend as much time on those. And in making these discussions, I want it to be as engaging and as interactive as possible. So from time to time, I'll come to you with certain questions. Please don't be shy. If the spirit moves you, then just throw an answer in the chat. It will be interesting to see how you're thinking about these issues and how you think some of the difficulties or some of the more practical problems might be resolved. So moving on, as to an overview, Professor Wahab in his presentation gave a framework, and I think my overview sort of mirrors that framework. So we'll be talking about legal considerations in organizing virtual proceedings. Can you even do it? Are you legally permitted to do it? To the extent that you are, then what are the technological considerations that you should be thinking about? And more importantly, what are the practical considerations you should be thinking about? I find that the practical considerations are the ones that are not discussed as much, and hopefully we will sort of share some insights as to what to do in a particularly given situation. Now, can you do it? Legally speaking, can you do it? Well, the first place you might want to look at is the parties' agreement, which, as you all know, forms the foundation for the tribunal's jurisdiction. Now, if the parties have not agreed to virtual proceedings and you proceed, then you run the risk of your award being set aside. So I've given the example here of Article 34 to A4 of the Ancestral Model Law, which allows a court to set aside an award if it was not in accordance with the parties' agreement. So invariably, you will find that most, if not all, arbitration agreements do not envisage virtual proceedings. So let's have a look at the first scenario. If the parties agree, should the arbitrator proceed remotely? Just throw an answer in the chat. I'm just interested in seeing what you think. Let's assume that your arbitration clause says we can proceed remotely if the need arises. In that scenario, should the arbitrators proceed? I'll give you a moment. Just throw an answer in the chat, and please don't be shy. So while we're waiting, let's have a look. Well, usually the arbitrators will defer to the parties' agreement, but you need to be mindful of the fact that notwithstanding the parties' agreement, if there is a mandatory provision in the lex arbitri, then it may not be safe to proceed. So if there is an express prohibition on remote proceedings, then notwithstanding the parties' agreement, it would be unwise to proceed. That said, most arbitration laws and most arbitration rules do not contain an express ban, but you may find a situation where the rules instead refer to an in-person hearing. Now, should you proceed in those circumstances? You probably could if you secure the parties' express agreement that notwithstanding that provision, you can proceed remotely. Now, let's look at the other situation. If one of the parties objects, should the tribunal proceed remotely? Thank you very much, Idrisu, for your answer for the first one. So what do you think for this scenario? If one of the parties says, I do not want to proceed remotely, and one says, I would like to, should the tribunal proceed in these circumstances? Again, I'll give you a moment. Just no. Prince Benjamin says, no, absolutely not. Well, as with all things in this circle, it depends. And I say this very carefully, but it really does depend. It depends on the reason for me. You have to look at it on a case-by-case scenario. So the first thing I want to look at is, does the lex arbitri allow remote proceedings? And as we saw before, most of them might not expressly say so. So you need to see whether the rules are flexible enough to give the tribunal discretion to proceed remotely. So that's the first thing I'm looking at. Now, the second thing I'm looking at is, will proceeding remotely affect a party's ability to present its case? If it does, then there are due process problems and you should not proceed remotely. Now, let me give an example of a situation we encountered in one of the first remote proceedings I was involved in, and I was involved in it as a sole arbitrator. Again, thank you for the answers, Idrissa. You're saying it depends on the other party's concerns. I agree with you entirely. Now, the situation we had there was that funny enough, the respondents sent an application to proceed remotely, and the claimant objected without necessarily stating the reasons for the objection. So the response from us was that, well, could you please articulate the reasons for your not wishing to proceed remotely? And then Claimants Counsel came back to say, well, we've incurred costs for travel, costs for hotels, we've prepped all our witnesses, we've made so preparations. So we went back to say, well, are these costs things that a tribunal could possibly remediate with a cost order? And are there any due process concerns you have with proceeding virtually? If you do have any, please articulate them. And at that stage, counsel sort of picked up on the tribunal's hint to say, well, we could probably recover our costs at the appropriate stage, and we do not actually have any due process concerns with proceeding remotely. But these are the things you want to be looking out for. Will proceeding remotely affect a party's ability to present their case? And you also have to juxtapose it with the tribunal's obligation to proceed in an efficient manner, both cost and time efficiency. So let's now presume that you've identified the legal landscape and there is nothing to prevent you from proceeding remotely. Okay, so next thing we need to think about is, well, what technology should we deploy to facilitate these remote proceedings? So there are a number of things to consider, and Madeline pointed out some of them. But in an ideal setup, right, you would want to see all the participants. And again, I'll throw in a story here as to why this is important. There was proceedings, this time we were involved as counsel. And prior to the first procedural meeting, which was also conducted virtually, we had agreed to submit a list of all participants. But at the hearing proper, there were several people in the hearing room who had not been identified. So there was a problem with the arbitrator saying, well, I can't proceed unless I know who these participants are. And some of them had their cameras off and didn't have names on the screens that corresponded with the names submitted to the tribunal. So sometimes if you're on a Zoom call, right, you'll see a participant who joins and their name is iPhone or A22 or something similar. So you need a platform where you'll be able to see all the participants. Something else you need to think about is some platforms, at least some that I've encountered, have a limit as to the number of people it will accommodate. So, for instance, I've seen a platform where there were only a maximum number of 6 participants could be on the screen at any given time. So again, if you're going to have quite a large arbitration, that's something you'll need to consider. Then the next thing you need to consider is the tech has to enable this, and you've heard it before, this synchronous communication between the parties. We need to be able to hear each person as they speak. And also, if any interpretation requirements are, if any interpretation is required, then does the platform accommodate that as well? Can you have an interpretation channel? You also need to be able to see all the documents being projected on the screen, as well as have access to those copies. So again, does the platform allow electronic presentation of evidence? And sometimes you will also need to have a live transcript feed, right? So you need to be able to see all the participants, you can hear them, you need to be able to see all the documents, and you need to be able to see a live transcript feed. This one's important. You need an open line of communication with your colleagues. And I think it was Madeline that mentioned closed chat groups. One thing you need to be mindful of is on a platform such as Zoom, for instance, if you're having a private chat with the chat function, the organizer of the meeting may still be able to see what you're saying. So you need to be able to ensure that whatever communication you're having with your colleagues is secure, and we'll come to that when we discuss privacy requirements. Now, with that said, what is the ideal setup? How many screens do you need? And this is a very helpful sort of portrayal by Professor Saiz. And you can see here, well, you have obviously your webcam, your main screen to see all the participants, to see the documents, a laptop to see the live note for the transcripts, preferably an external mic or some very good headphones to minimize any interference. And you'll probably need another little screen, in this case, a tablet for the electronic bundle, and your cell phone to keep in communication with your colleagues. If a good tip here is if you have WhatsApp for web, that's a very easy and a cheap way to keep in immediate communication with colleagues as the proceedings are going on, and you have the added bonus of security as well. So this is suggesting that you probably need at least 3 screens, but it is doable if you have less than this. So now, what platform do we use? Again, and I've mentioned, does the platform support the required number of attendees that need to participate in these proceedings? Does it allow an additional channel for interpretation? Does it permit live presentation of the documents? So you need to consider this at an early stage, and as an earlier stage as possible, usually at the first procedural meeting, where each side has a chance to discuss. You sort of identify what are the material issues that will come up. Will it be documents only, as Madeline mentioned earlier? Is witness examination required? Are expert examinations required? What sort of platform will accommodate this? And I see in the chat that Prince Benjamin says that, well, a cloud platform is preferable. It could be, it depends. So again, I'll go back to a story where in the first virtual proceedings we had to facilitate, that was an option of a cloud platform. And what ultimately put the parties off was the cost of that platform. And we ended up having to use I think it was Microsoft Teams, actually, because that accommodated everything the parties needed. It had the video conference element, it had the document exchange element to it, and it had private chat rooms as well. So cost is an element that will determine what platform you use. Privacy and security, very important here. And there are two aspects I want to highlight. Naturally, you want the hearing room to be secure. So you only allow those who are permitted in the arbitration to participate. But you also need to consider as well privacy laws that may be applicable. For instance, if one of the parties is in the European Union and will be exchanging documents with a party that is in Africa, then you need to consider things like the provisions in the GDPR, which prevent the transmission of data as it concerns an identified or identifiable person, unless the recipient of those data has similar protections to those that are given under European Union regulations. Likewise, you need to consider whether laws in your respective jurisdictions, there are data protection elements within your respective country. So if you're in Nigeria, you'd want to consider the Nigerian data protection regulation. But in terms of securing the hearing room, these are things with which we're all familiar by now. At the very minimum, you should have a password protected hearing rooms. The party should disclose a participant list in advance to prevent any surprises at the hearing. And like I said, be mindful of privacy requirements under applicable laws. So contingency measures in terms of technical failures. For us, being in a continent that is, we have connectivity issues. In some places, we have also power issues. So you need to have a protocol as to what would happen in the event of a problem. In the first one we did, the protocol was, well, if one of the parties drops off, everybody has to turn off cameras and videos. Cameras and microphones. The recording was left on, so you could go back to it and make sure that nobody was communicating ex parte. And we gave the party that dropped off a time limit to join. And if they were unable to join, we would stop proceedings for an hour and then give them, the tribunal secretary would communicate with them by telephone and see if we could get back on. For us, you should always have backup devices. So from where I'm speaking to you from, we have 3 internet connections. So if one fails, we'll quickly jump onto another one. Likewise, you should have facilities for uninterrupted power supply. So for us, we have a solar inverter. So if the main grid goes off, then the inverter kicks in and we can still have that synchronous communication. And likewise, the tribunal should have alternative means of communication. So what I mean here is, if one of the parties is unable to communicate via the video conference, should we have a redundant telephone as a backup? So one of the parties could dial in and hopefully we could still see them on the camera, but hear them from the telephone connection. But very important to think of what will happen if things fail. Another thing you need to think of is how do you treat documents? Very important aspect of it, because for the online element, you do not have, you may have physical documents, but for the online purpose, for everybody to see where the document you're referring to, it's very likely you will have an e-bundle. So you need to determine how will those documents be shared. Madeline very helpfully pointed out the iResolve platform, which I commend very strongly. And there are other platforms as well that will have a document exchange platform on them. But if you're not using one of these more sophisticated platforms, you need to decide whether, are we going to have a virtual data room? For instance, should we use a Microsoft SharePoint for the central location for all the documents? Or should we exchange them using a file transfer protocol? Now, if you're using an agreed bundle, another thing you need to ensure is, how do we refer to document the pages in the document? So imagine you have a compilation of documents that each side is relying on, and in each of those individual documents already have page numbers. Then in your compiled documents, that also has page numbers. So something you may not think about is, well, which page references are we referring to? Are we referring to the page references embedded in the original documents, or are we referring to the page references in the newly created documents? That will save you a lot of time and a lot of problems if you decide that as early as possible, because you don't want a situation where one side is referring to the embedded numbers and the other side is not quite following where to go. And also consider, in addition to the electronic bundle, also provide a hard copy bundle to each of the parties, particularly where the witnesses are in different locations. And if one of them has a problem accessing the e-bundle, or they do not have screen real estate that will accommodate it, at least they have a hard copy that they can refer to. Also agree on a protocol for delivery, right? Are you going to deliver solely electronically or electronically and in hard copies? If you are delivering in hard copies, particularly to a witness without the assistance of counsel, it may be worth having that witness undertake not to access the bundle before testifying. Video and audio directives is a practical consideration you want to also think about. Should all the participants always have their cameras on? Now, imagine it's a big arbitration, you have up to 30 people. It might be a bit distracting to have 30 cameras on at the same time, trying to pick out who is talking at any given time. So your protocol might be to say, well, only active speakers should have their cameras on. So in a hearing scenario, you might want to limit that to the tribunal, the witness, the examining lawyers. Now, also have a protocol for what do you do if you want to raise an objection. So while a witness is testifying and counsel wants to raise an objection, how do you do that? So it could be as simple as, well, if your camera is off at the time, turn it on, and it will bring the tribunal's attention that you wish to make an intervention. Or you could use the hand raise function, which is available on most video conferencing platforms. So for witness examinations, the practical considerations here that you need to ensure that you have the best possible video and the best possible audio quality while connecting. You may not necessarily have an equal technology with your counterparty, particularly if they're in a jurisdiction where technology has become the mainstay. Nevertheless, you need to ensure that whatever technology you're using and whatever connection you have, it is the best possible connection you have. So I need to be able to see the witness and hear them properly and immediately as well. If a witness can leave home, then consider whether it might be a good idea having them testify from a neutral location. So for instance, they might go to a law firm or a hearing center if one is available. Alternatively, you could also consider having one of the party representatives present where the witness is to assist with logistical issues, with technological issues. So not only, as Madeline said, should the tribunal be tech savvy, the counsel should be tech savvy as well in order to assist their witnesses and clients where necessary. Something else you need to think of is the parties in different time zones. And if they are, which time zone should govern? So one way I've seen it done is to say, well, the time zone of the seat should determine when the proceedings will take place. But if you have extreme scenarios where you have one party, for instance, in the East Coast, or sorry, in the West Coast of the US, and you have another party in Asia, then those very extreme time differences could occasion some hardship. So you may want to spread the difficulties equitably. And what I mean by that is if one party testifies very late at night on one day, then ensure that on another day they're given a very or a more favorable time slot. Objections I've mentioned, it's very important to establish a protocol for mentioning objections, because you want to keep the proceedings as orderly as possible. If I just jump in and start making objections, it makes the hearing quite incomprehensible when you have people talking over each other, particularly over an online platform. Again, hearing times, I've already mentioned this. For the host, you need to determine who will host the proceedings and what level of control do they have. If you're using an arbitration center, then naturally they will host it for you. If you are not, because of costs, well, you need to determine who will host. Should it be the tribunal? Should it be only the presiding arbitrator? Should it be a tribunal secretary? What level of control will they have? Should they be able to mute microphones, turn cameras off, on and off? And again, why this is important is from a war story I've heard, the tribunal in a particular case turned off the microphone of a party that was being disruptive. And that led to that party challenging, and I should say unsuccessfully, challenging the proceedings on the ground that the tribunal prevented them from being able to present their case reasonably. But if you establish this at the very beginning to know that, well, if a party is being disruptive, the tribunal can turn off microphones, can turn off cameras, then you manage expectations, and it doesn't come as a surprise to the parties if that happens. Bear in mind that online fatigue is real. So hearing days might have to be shorter, particularly if you need to accommodate different time zones. And take frequent breaks just to allow the parties to sort of rest their eyes, stretch their legs, etc. Madeline mentioned this, and this is very important. You need to be able to narrow the scope in virtual proceedings. So as an example, there's an arbitration in which I've just been involved, and one of the parties didn't quite get this message and wanted to put in as many documents as possible, even documents that did not go to any disputed issues. And what that will do, it will prolong the proceedings. It will make it more complex than it needs to. Think the simpler, the better. So if you're able to narrow the scope and focus only on the evidence that can't be dealt with exclusively by documents, then it will make it more efficient, right? So you just focus any witness hearings to those disputed issues and try and make it as streamlined and as efficient as possible. In terms of helpful resources, you've already heard some of them from the other speakers. I commend in particular the African Arbitration Academy protocol on virtual hearings in Africa. But there are very many others, particularly now as we are going through, as virtual proceedings are becoming more of the norm rather than the exception. So each of these you'll be able to find online, and they provide very helpful guidance as to what sort of protocol should you adopt in virtual hearings. So I'm mindful of the fact that I want this to be more of an interactive discussion rather than me just talking to you. So I hope this has sort of stimulated some ideas in your head, and I look forward to any questions you might have regarding some of the practical aspects that might arise during virtual proceedings. So thank you very much, and I'll bow me back to you.
Thank you very much, Isaiah, for, again, those useful insights. I see a couple of questions in the Q&A box. I'd promised that we will not use more than 1.5 hours. So right now we're going to about 2 hours. So I think we have just 10 minutes to take those questions. So what I would just do is to ask those questions and allow the panelists to intervene. Isaiah, there's a question for you in relation to cybersecurity concerns. So how do you sidestep those concerns? Prof asked, in addition to the first question I asked Prof, there's a question from Dalila Yusra that says, will you please tell us about your opinion on the enforceability of smart contracts, blockchain technology, and the predictable risk of them? So those risks implicated by those kind of contracts. And Madeline, there's a question for you that how would the arbitral tribunal deal with illegally obtained evidence through Akin? Would the tech expertise report suffice to actually establish proof of the hacking to prevent the other party from relying on it? And Prof, last question. When Isaiah was speaking, he spoke about on the question relating to whether the arbitrator should proceed remotely or with virtual hearing if one of the parties object. I know you published the up to our pandemic pathway. You may have an intervention in relation to that question. And so we'll start with Prof, then Madeline, then Isaiah, then we'll call it a day.
Thank you very much, Abayomi. I very much enjoyed the presentations of my colleagues and your very capable moderation. I will be very brief in response to the questions so that we have time as well for Isaiah and Madeleine to address the questions. So your first question was basically ODR potentially taking over and where does Africa stand there in terms of the technology? Let me tell you the following, of course, and I'll be very candid. Africa is the last standing continent with the greatest potential of investments, a green field. So all eyes are on it. And every person or entity across all continents have a vested interest in investing in this. So I think Africa is booming and a lot is already taking place. Where do we stand? Of course, we are lagging behind in terms of the technology, especially secure servers and connectivity issues across the continent at large. There are, of course, hubs where we see certain parts, of course, Nigeria, Egypt, South Africa, Rwanda, Kenya, where they have, made leap steps in terms of ensuring that they're aligned to an extent with best practices in this respect, but still a lot remains to be done. So I think, and that's one of the potential areas. I think traditionally we think of course, infrastructure, construction, and energy, but I think telecommunications and ICT is an area where we will see a boom in terms of the investments. And that's an area where, of course, African free trade, the Continental Free Trade Agreement will play a key role. So I think it's a lot, we can expect a lot more in the coming few years. In terms of the blockchain technology and smart contracts, let's remember one thing, that smart contracts normally are self-enforcing. The whole idea of smart contracts is that you wouldn't need to go for an external type of enforcement mechanism one way or the other. But that said, and with blockchain, which is a huge boom, and I think many people have now vested interest, still they're not risk-free, of course. And the way, for those of our colleagues who are not aware, basically blockchains is based on a distributed ledger technology, where we have blocks and every change in one block is seen and impacts a change in another block. And so it's not in one location where you do a change, it cuts across the whole network of connected computers or devices in this respect, which makes it difficult to make an unnoticeable change or tamper with it. And that, I think, is one of the high watermarks of the use of this technology. Nevertheless, nothing is risk-free, be it in terms of technology or traditional ways in a way. If we consider the risks of blockchain, I think simply the lack of standardization is an issue. We see that there is a lack of standardization across those engaged in blockchain. There is also no uniform valuation of cryptocurrencies generally. So we have underdeveloped standards, no uniform valuation of cryptocurrencies. We have protocols that may not be easy to integrate in each blockchain. And of course, there are human-related risks. So hacking is not impossible, but difficult. If you engage in hacking, this means you have to alter each and every block in the blockchain itself, which is not easy. And of course, you have risks of public and private key and risks of vendors and untested codes. So pretty much very technical. On the legal risks, I think data privacy and regulatory risks remain at the high end, because not many countries have regulated this so far, and privacy issues remain at the forefront of those risks. This is by and large my response to these questions. Now, in terms of Isaiah's excellent presentation as well on virtual hearings, Yes, I did write the pathway, and you are kind, of course, to have a commentary published as well on this. And I think again, the essential question is what happens if the parties disagree? And here I can refer people to my publication where I identified a number of criteria on the basis of which tribunals would need to navigate their decision. And of course, one aspect which is interesting, people may see different perspectives. Do we have a legislative coverage that enables the tribunal continue, or do we have a legislative prohibition to prohibit the tribunal from continuing? Depending on the jurisdiction, the general answer is that absent a prohibition, depending of course on the legal system, the tribunal has discretion. But in doing so, you have to consider elements, of course, of due process availability of technology. There are certain parts, at least on the continent, where people don't have connections. So how can you enable a party to present its case absent a connection? That is distinct from using state-of-the-art technology or a reliable technology, because you will always have variations across parties as to access of technology. But the question really is whether we have sufficient technology to enable a reliable connection for a party to present its case. I think COVID has taught us that in certain situations, it is unavoidable to hold a hearing virtually, and people have navigated their way in this respect. I've had a number of hearings where even though one party could not access or had no reliable connections on the continent, they traveled to a neighboring country to join. So close enough, you made the trip to a neighboring country to be able to have a reliable connection. And on the point that Isaiah helpfully mentioned, which is populating the screen with many access points, again, practice has shown recently that people join from what they call remote hubs. So you'd have counsel team joining from one hub, so you can see one screen where counsel together in one place or an expert in another place. So there are ways to deal with that. The question, of course, is a post-COVID, whether it would continue. And I'm saying it's going to be an option alongside physical hearings. Of course, post-COVID, people would want to meet physically, so there will be a surge in physical meetings and hearings, but virtual hearings or hybrid forms are not going to go away.
Thank you very much, Prof. Madeline?
Thank you, Abayomi. Well, your question really is very complex. I would say that there is no particular way to approach it in terms of how an arbitral tribunal should handle or will handle when it does happen that there is illegally obtained evidence through hacking or any other means, because it could be not even from the hacking. It could be through other methods of cooking up some evidence that could render it to be illegal. Now, with an arbitral tribunal, most legislations which have adopted the model law, the arbitral tribunal has power to determine the admissibility of evidence. And the approach that I would say would be that this should be handled on a case-by-case basis, depending on the facts before you, in order to minimize the risk of that award being either challenged in any sort of way for ignoring any particular documentation or evidence that has been tabled before it. I think that arbitral tribunal would have to tread very lightly in terms of determining whether to apply that evidence or not. Now, applying it, of course, the relevance, the materiality of it all, whether it has an impact on the outcome of the dispute, all these factors, or even the severity of the illegality needs to also be looked at. Now, if you have this tech expertise report that gives you sufficient proof of the extent of that illegal evidence, then that could be something that could make some sort of weight to the arbitral tribunal's decision making in terms as to whether to take it into account or not. I was looking at the Article 9, subsection 3 of the IBA Rules 2020, and that wording that is provided there, it says that it may, at the request of the party or in its own motion, exclude evidence obtained illegally. And so if that particular arbitral proceedings have adopted the IBA rules, especially the new 2020 version, then they would have that option there in terms of assessing the risk aspect that could come around to the award if that particular evidence is ignored or taken into account. And of course, the national laws, I would add, are something that would have a major impact on the decision making of the arbitral tribunal, because some national laws do provide for admissibility of evidence in arbitrations. Yes.
Thank you very much, Madeline. Isaiah?
Thank you very much, indeed, Abayomi. So in relation to how to avoid security risks in the arbitral proceedings, I think the first thing to ensure is you need to identify what are the points that the information leak is most at risk. So there are two levels you need to consider. You need to consider communications within your own team. So communications from your client to yourself. And then you need to consider communications within the arbitration itself. So, there are very practical things you should do. If you are sending documents through email, for instance, do not use unsecured platforms. So do not use, for instance, the commercially available ones like Yahoo Mail, Gmail. Ensure that whatever system you are using has sufficient encryption to prevent a data leak. Likewise, the virtual platform you are using, ensure that the encryption, again, is sophisticated enough to prevent a data leak. And one thing we have to be mindful of is whether the proceedings are virtual or physical. If one of the parties or if a third party is motivated enough, they would probably be able to access those proceedings in one way or the other. It's literally a case of what steps do we take to mitigate those risks from happening. One other thing to consider is if in the event there is a data leak, should cost sanctions follow? So if there is a major data leak, should the tribunal be empowered to sanction a party with costs? That might be another way of motivating the parties to ensure that in exchanging documents and sending sensitive information, they have taken sufficient measures to ensure that that transfer is secure to prevent the risk of a data leak. And if I may just briefly comment on the question put to Madeline, there are some jurisdictions, and I'll use a Nigerian example, for instance. On the Nigerian law, illegally obtained evidence is admissible. So that might be a factor that might motivate tribunals thinking if they are influenced strongly by the legal backgrounds from which they come. However, I have seen, and this was in litigation, but I have seen where illegally obtained evidence is admissible in order not to encourage that, in order not to encourage the steps of illegally obtaining that evidence, there were quite heavy cost sanctions on the party that took the steps to obtain that evidence illegally. So that's another aspect I've seen.
All right, thank you very much, Isaiah. And given time constraints, I think this is a very good place to draw the curtain. Thank you, Prof. Madeline and Isaiah, for taking out time out of your busy schedules to speak to us today on these important topics. Many thanks also to all the attendees for being part of the session and for those useful questions and contributions. I know lots of people have been asking questions about the recording and the slides. With the kind permission of the panelists, we'll be sharing the slides and the recording with the attendees and those that registered and couldn't attend. The training continues tomorrow for the Portuguese-speaking practitioners in Lusophone Africa. I know one of the speakers for tomorrow, Luis Abram, is also one of the attendees today. Thank you, Luis, for joining. And we'll also be doing another session for Francophone Africa in the next few weeks. So thank you very much for joining. Enjoy the rest of your day. Stay safe and bye for now.